Good afternoon, everyone. We're going to get started because it's about 5 minutes past the hour. I want to be respectful of your time. And as folks come in, we will let them join us. We can throw things at them, call them names, go from there. I just wanted, before we get started, can we just see who's in the room? If folks are best interest attorneys with the Guardianship Litem program, can you raise your hands? Great, welcome. What about case management advocates? What about CASA volunteers or Guardianship Litem volunteers? Yay, me too. What about children's attorneys? Yay, me too. What about parents' attorneys? Yay, me too. What about state's attorneys? Yay, not me yet. Anyone else? Judge? I'm from the State's Protection and Advocacy Agency, Disabilities Rights, Florida. Great, welcome. CBC, case managers, supervisors, program managers. Well, welcome everyone. We're going to be talking today a little bit about the Regis Little Act and what it means in terms of the probate court, but also the juvenile court implications. And before we get started, let's go ahead and introduce ourselves.
Hi there, Attorney Michelle Kenney. I am founding member of the firm GAPS Legal. Guardianship, Advocacy, Probate Planning, and Special Needs is our focus. I've actually been in the guardianship community for a little over 20 years now in various capacities, and was very fortunate to work with Jessica, and she'll tell you a little bit about FJTC in the development of the Turning 18 website. So we're here to certainly share some of my journey being in the guardianship world for 20 years and where we can hopefully make some improvements on it.
My name is Jessica Ray. I have been a kids lawyer for about 20 years. I worked at the Guardianship Litem program in Pasco County and then in Pinellas County, and now I am a CASA volunteer in Denver, Colorado. I recently joined the Florida Justice Technology Center. It is a nonprofit tech organization, and we use technology to address unmet legal needs to make the law accessible to the lay person. And one of the projects that we did was turning18.org, and that walks parents and families and friends through the process of seeing what their options are when they have a loved one who has developmental disabilities. And we partnered with Michelle and her law firm to develop the tool because we thought it was an unmet need in Florida. And it's really relevant in child welfare because of the Regis Little Act, which came into effect in 2015. So that's what we're doing today. As we come up, as we go through the slides, and if anyone has any questions, feel free to ask. We may ask you to leave it to the end if it's going to be a bigger discussion, or we'll tell you if you're jumping ahead. But other than that, let's sit back and enjoy. Skip one. Okay, Regis Little. Who's familiar with the story of Regis Little? Okay, so most people in the room, Regis was a young man that came into the foster care system as a little kid at 18 months old. He died shortly after his 18th birthday, after he had aged out. And the concerns were that Regis had a lower IQ and intellectual disability, and the thought was that did he have enough support when he aged out of the foster care system to prevent his murder? What we know about Regis is in the years that he spent in foster care, he had unstable placements, he moved from education setting to education setting, involvement with the delinquency system, also was on a number of medications, which for most of us, that sounds like many of our kids, right? So Regis, sadly, is representative of a lot of young folks that are involved in the foster care system. And we gave you an example of another young person named Ashley. If folks have grabbed a copy of the hypothetical, just want you guys to pull it out and think about Ashley's case as we go through this presentation. So the first thing I'd like you to do, if you have a pen, is I'd like you to write down the purpose of the Regis Little Act. Okay, here we go. The purpose of the Regis Little Act is to appoint guardians for children with developmental disabilities. Please write that down. Everyone got that written down? Okay, now take your pen again.
One more time.
Oh, sorry, one more time. The purpose is to appoint guardians for children with developmental disabilities. Everyone got that? Okay, now cross it out. Cross it all the way out, scratch it, write big no, 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 no. That is not the purpose of the act whatsoever. The purpose of the act is to ensure that children with developmental disabilities have the support they need. And in fact, you could probably cross out the word developmental disabilities. Isn't that what we're supposed to be doing in the foster care system, is making sure that children have the support that they need? The Regis Little Act. Sure, sorry. And again, throw something at me if I'm speaking too fast. The purpose, the true purpose of the Regis Little Act is to ensure that children with developmental disabilities have the support that they need. Okay? And again, crossing out developmental disabilities is also optional. The reason for that is we want to make sure that kids have the support that they need that is in the least restrictive manner possible. Does that make sense to folks? Okay. So what does that mean? Okay, here are the requirements under the law, the Regis Little Act. The first one is we want the agency to begin to identify kids that may need additional support. We want to have a case planning conference. We want to make sure that the court has reviewed what is being recommended in the case plan. We want the court to say, yep, we think that there is a need to do something more. We want to look at possible reports, and don't you love acronyms in foster care? MDR, that stands for a multidisciplinary report. We want to look to see if there are possible identification of guardians, and this is one area of the law which I think is wrong. It should say identification of possible supports, because it already assumes that we need a guardian, and that may not be the case, but that's what the law says right now. Potentially initiate guardianship proceedings, and then to continue to review the need for that on an ongoing basis. So let's just go quickly through those steps. So when we're talking about the kids that we're identifying, we're talking about two sets of kids. The first are the kids with developmental disabilities. Those are the kids that fit within very specific criteria, and I'm going to read them to you. The first one is intellectual disability, children with cerebral palsy, autism, spina bifida, Prader-Williams, Down, or Phelan-McDermott syndrome. So those kids that fall within that category are in that first grouping of kids. The second is children with some sort of incapacity. And folks often ask me, well, what does that mean? What makes a young person incapable? It doesn't mean that they're making bad decisions. Because if that were the case, every single one of us in this room would have a guardian, right? Because human beings make bad decisions all the time. We're under stress, we're under pressure. Sour Patch Kids for dinner sounded like a really good idea. You know, whatever the reason is, we make bad decisions, right? So the legal definition of capacity or incapacity is the inability to manage at least some property or meet some of the essential health and safety needs. So those are the groups of kids that we want DCF to identify.
And Jess, I'll also add to that, it may be a child with a mental health diagnosis, distinguishing that from a developmental disability. The other thing too is when we're talking about young adults, those that are 18, so not only making bad decisions, but they may not have yet acquired the skills to make certain decisions. I mean, just those life skills a lot of times are lacking in even our typical young adult children. So distinguishing between bad decisions, an inability, and an actual incapacity. That's the distinction that we're looking for there.
So once the agency has said these are the young folks that are on our caseload that may fit in those categories, we want to have a case planning conference to talk about, well, what should happen when the young person transitions into young adulthood. At that case planning conference, you're required to have the folks that are here under the required list: the youth's attorney, the guardian ad litem, the caregiver, and the parent. Notice it says the youth only if appropriate, and if the meeting is about the young person, it should be really rare that the young person isn't involved in that meeting, right? Then the parents, if not TPR'd. But let's think about some of our cases where parents have been TPR'd. They may have been TPR'd years ago. Parents may still be actively involved in the young person's life. So these are the requirements. It doesn't mean that they have to be excluded, right? And then what I'd like folks to think about is really consider all the other folks that you could include in that meeting. So I've included the relatives, parents, whether they've been TPR'd or not, siblings, caregivers, teachers, folks from APD, if the children are already working with the agency, disability advocates, community resources, and my favorite, the orthodontist. And let me tell you why I have orthodontist on that list. Years ago, I worked with an agency to remove kids or move kids out of group homes into the community. And what we did is we worked with kids to identify the people that were important to them. And at first, when you sit down in a room with adults and everyone's staring at the child, and of course we all start strength bases, we have to say nice things about the kid, which is really embarrassing for the young people. Generally, they don't like that. And we said, well, who's important to you? We really put kids on the spot. So what we did instead was we gave them a list of all these people that might be in their life and said, go ahead and circle them and see who's important to you. And we had this massive list, and one of the kids identified a principal from grade school who then we invited to a meeting who found out that they remembered a relative, and we found the kids the placement. So what this list is, an orthodontist, is just to remind you to think creatively, that it can be anyone who's important to who? The child, and potentially the child's family, the child's parents. Does that make sense? Okay. Yes?
Under the required Kenney gap, is that assuming that the gal is a surrogate parent?
Oh, great question. So the question was, is the guardian ad litem, is that assuming that the guardian ad litem has also been appointed as the parent surrogate? The answer is no. The statute doesn't require that that had already been in place. And in fact, that may be something that maybe we should add on this side, is that if there's a parent surrogate that's operating on the IEP, and that's not the guardian ad litem, that would be another person to add. But this is the guardian ad litem that has been appointed through the dependency court without any additional requirements.
I know that there's I'm from Pinellas County, and there's a concerted effort by the school system to get guardians certified as surrogate parent, because there's a growing need for the child to be represented
In the IEP process. So the comment was that in his county, Pinellas County, that there's a concerted effort to have the guardian ad litem volunteer become certified to be a parent surrogate in the IEP or special education process. Florida statute allows for that. There are provisions for that. And in general, that would be a good thing, right? Because it's someone who knows the kid and probably has more history on the young person than other folks who maybe are just randomly assigned. So that's a good thing, but that's not a requirement, a specific requirement under the statute. I saw one more hand.
I have two quick questions.
Sure.
First thing, you started with timing. The time and a lot of the animal evidence in Hillsborough is to start when the child turns 17. Do you recommend that age or another, or
Okay, so the question was the timing of this meeting, when should it be? In Hillsborough County, they start at 17. This planning should probably start the moment the young person comes into care, or the moment that a child has been identified as having a potential need for additional supports once they turn 18. 17 is way too late, and that's why I wrote timing under the first slide. And we'll get to that in a second, and I'll also explain to you why I'm not even sure that it really is 17, because those of you who have seen me talk before know that I just love the statute. And it is internally inconsistent about when things are required at what time. So yeah, early and often would be my suggestion for planning for kids who are aging out. And if we're starting to plan at 17 and 6 months, we are probably way too late and are going to be scrambling.
Next quick question is, you mentioned statute twice. What number statute?
Okay. You're so tricky. So 39.6251, Section 8. Wouldn't it be really impressive if I just whipped that off without reading it? 39.701, Section 3B. 393.12, Section 2C. And 744.301, Section C. See, I knew the question was coming. Okay. So once you've had that case planning conference, there's going to be a judicial review, and the court is going to have the judicial review in addition to all the regular things that the court does at the judicial review. The court has to make a determination. This is a judicial determination, not a recommendation from the Guardian ad Litem program, the child's attorney, the parent's attorney, or DCF. This is a court determination that the child qualifies for either a guardian, a limited guardian, a plenary guardian, a guardian advocate, and that there are no least restrictive alternatives available. So that's a finding that the court has to make. And then the big question about when does this decision make? And my answer is, kind of around that 17-year-old birthday. And the reason why I say that is that the statute says that there's supposed to be a hearing within 90 days of the child's 17th birthday. It then also says subsequent to the child's 17th birthday, and then it says within 90 days after the child's 17-year-old birthday. And let me tell you, if we're having this first hearing when the child is 17 and 3 months, we have missed the boat. It is way too late, right? So, again, that's what the statute requires. There's no prohibition in having these hearings earlier or beginning this process earlier. The only prohibition, or the only tool that Regis Little adds to the law, allows us to file the guardianship proceedings at 17 and a half. It's a tool, it's not a prohibition. So that's the additional thing that Regis Little provides for us. And here are the big 3 musts. When the court determines that a young person may be eligible and there are no least restrictive alternatives, the court requires DCF to do 3 things, and potentially it's 2.5 things. The first thing is that there must be a multidisciplinary report. That report has to have an educational component, a psychosocial component, but it's not defined anywhere in statute or the regs, and it says that it has to be recent within the last 2 years. And folks sometimes, I've watched some videos on other trainings, and folks get hung up on, well, does the CBAH count, and what about an IEP with a psychosocial? What really counts? Guys, remember the purpose of this act. It's not about checking boxes that a report has been filed. It's about getting the information that you need on the young person to figure out what the young person needs. So don't worry so much about the form, worry about the content. Does that make sense? Okay, I will now step off my soapbox. Okay. The second thing that DCF has to do is identify folks who may be willing to serve as the guardian advocate or guardian. Again, put an asterisk there because that's what the law requires, but it could be other folks. It doesn't necessarily need to be this intrusive. It could be folks that can serve as other supports that don't rise to the level of guardian advocate or guardian. And then if the child does need a guardian or a guardian advocate, begin those proceedings in probate court. Those do not happen in juvenile court. Okay, so let's talk about the gigantic elephant in the room. The question was, we've gone through the whole process, we've decided that the young person needs a guardian advocate, but we can't identify anyone. And that is the elephant in the room. Great picture, right? Me on safari, right? Very cool. Okay, sorry. So yeah, that is a huge issue that folks are facing from county to county to county, and we're gonna talk about that. So, before I turn it over to Michelle, what I'm just reminding everyone is relax. We're going to start to talk about strategies to identify the resource needed. We're going to get there, we promise. Now Michelle's just going to walk through what happens as we're going through those steps. Because as I mentioned, the juvenile court has made that finding that a guardian advocate or a guardian may be needed. It doesn't mean that someone is now automatically appointed. The process now has to begin in probate court, and that court in those adversarial proceedings would make that decision. So nothing is final yet. So I'm going to turn over to Michelle, and then we'll go back to figuring out how to identify those resources. Everyone with us? Okay.
We're going to start with turning 18.
Actually, folks, do you have if folks have smartphones or their computers and you're hooked up to the internet, if you guys would like to go to turning18.org/. So the word turning, the number is 18.org. That is our interactive website that will follow along with Michelle as she goes through the options.
First, those fun statistics. So the numbers of children that we may be talking about, and this is obviously, scary to think close to 60,000 children, that these sorts of options or these sorts of considerations might be appropriate. And when you talk then about a lack of resources, that really starts to sound even scarier. But ultimately, what I want to make sure you understand, because I live in the probate world, so guardianship chapter and chapter 393, some of the ones we'll be talking about. First place I always start in any presentation is good guardians don't do guardianships. It should be good guardians, good guardianship is about not doing it. We don't want to do it if we don't have to. And where I'm going to start is really what is the most restrictive option, and so that you understand that and why we don't want to do it if we have other options that will meet those child's needs. So we'll talk about guardianship. So again, we're going to be going kind of down the scale if you want to look at it that way. We'll talk about guardianship so that you understand how invasive it really is. Then we'll talk about guardian advocacy, where they're different, where they're similar, whether or not supported decision-making might be appropriate for that child. And unfortunately, sometimes nothing is done. So it's not a viable option, but it's there because sometimes that's the path that we take as well. So then what is guardianship? I always start, so this is chapter 744, and in the opening paragraph, we have the legislative intent. And I think this is where, with all the legalese that normally we have in the statute, and you talk about ambiguities and not always liking statute, this is the one place I like because I think it's straightforward and clear. We don't want to do a guardianship that we don't have to. We want it to always be a last resort. If you take nothing away from today other than it should be a last resort, even though the provisions are there to do it, that doesn't mean we have to, if there are other ways to protect this child. We are talking about making it only as invasive as it needs to be, to only meet those needs that otherwise, if they can be met with alternatives, we want to leave intact as much as possible for that individual. We also need to appreciate that it's not one size fits all. So comparing one guardianship to another guardianship, we kind of throw it around as it's an appropriate solution, but there's an individual at the center of this, and they all have different strengths, different abilities, different needs. So this is where, again, I think statutorily it's pretty clear and obvious that the intention is to really not do it if we don't have to. So basic definition, so you understand some of the terminology we'll be talking about. The ward, or actually the alleged incapacitated person, is just the subject of the proceedings. And then ultimately, if we have a guardian or a guardian advocate, those terms are somewhat interchangeable. And when we talk about guardian advocacy, this is where it gets kind of interesting. It's in a separate chapter, but then it says see 744 for all the rules. So that's where, if the terms are used differently, I will certainly point it out to you, but otherwise they're interchangeable. That is then just going to be the person that is empowered to make decisions on behalf of the ward. They're the decision maker. And I make that distinction, and I think this is where Jess and I see it sometimes confused. That doesn't mean they're the caregiver. It doesn't mean they're the custodian. They are strictly the decision maker empowered by the courts. And that's a big distinction to make. There is a court-appointed attorney in this process representing the interests of that young adult. So we throw another attorney into the mix, but they have due process protections, and certainly the right to counsel is one of them. A guardian or a guardian advocate, when they're appointed, are then accountable to the court on an ongoing basis by filing plans. So think of it as a plan of care, similar to an IEP, a little bit different, but ultimately for personal matters. Then if there are finances involved, there might be financial accountings. There may be co-guardians. Maybe we have more than one family member that wants to serve. Sometimes we end up with maybe there's a family member in state and out of state. Serving as co-guardians means they're equally empowered. It's a little bit different from the standby guardian, which would be a next in line. And I know your problem is finding one to begin with, so finding a standby is probably the unicorn. So I do understand that, but they're not presently serving. They might be, well, maybe down the road if something were to happen to the principal or the primary guardian that's serving. Limited and plenary, we'll get into the distinctions between those two, but it's the scope of the guardianship. Is it complete or plenary, or is it more limited, meaning the rights that that individual might have retained? The letters of guardianship we'll get to, that's the kind of proof to the rest of the world that somebody's the guardian. You know, when somebody says, show me your paperwork, that's normally the paperwork we're talking about. And then next of kin, the statute actually defines it in probate. Those are the people that hopefully we have in this child's life that we could turn to in this role. But the process, so this is a quick overview for you, and then we'll talk about some of the specifics here. The court doesn't know who is incapacitated and who isn't. They're not out there looking. So we have to start the process by petitioning to determine that the person is incapacitated. It's actually a two-step process. There are two separate petitions that are being filed concurrently. One is generally going to be to find that there is an incapacity. The other is then going to be who is going to step up to be the guardian. We can't really ask to have someone found to be incapacitated and leave them without a decision maker. So the court's normally looking for that other petition to see where are we going to turn for that solution. Those get filed with the court, and at that point, the examining committee gets appointed. We'll talk about them in a minute. That court-appointed attorney gets appointed, and ultimately the timer on when a hearing has to be held, when reports have to get filed, starts ticking. And there's about a 2-week window in that time frame. Then ultimately, this evidence is going to come before the court. There's going to be a hearing, and ultimately then the court will make some sort of determination on the incapacity, and again, then who might serve if there is an incapacity. The ongoing supervision by the court is for as long as that person needs to have that guardian, as long as there is a guardian serving. This is a legal relationship. So I say to some people, I do a lot of education locally. Guardians have to take a class, so they get stuck with me for that. And I tell them, how long is this individual going to be incapacitated? And with a developmentally disabled child, what are we talking about? So how long is that guardian going to have a legal relationship with the court system? That's a long time. And I joke and I say, okay, you're on trial for murder. You're normally in a couple years, kind of know your fate. But in the case of a guardianship, that legal relationship is ongoing as long as we have someone with rights that have been removed. We have the court supervising that relationship. So that, I think, makes it even more challenging to have someone step up when you understand the magnitude of what we're talking about here. But that court relationship is ongoing. It's not kind of a, we go through this process and we're done. So some of the steps that are involved, we have to give the court an idea of what is the nature of the incapacity. And this is one of the few petitions that the examining committee is going to see. So we don't just say, for instance, well, they have autism, so therefore they're incapacitated. Well, how does that make them incapacitated? Do they have problems with processing information? Do they have some sort of inability to understand managing money, basic financial skills? Sometimes we might look at an IEP for an idea of maybe, what are the goals that they're working on in school, looking at their reading level, looking at some of those social skills. But ultimately, what are the things they can't do for themselves? Could they coordinate doctor's appointments? Could they otherwise determine where they lived? What makes it that they're incapacitated? Not just, again, that they don't have the skill set yet. And ultimately, we do ask about an attending or a family physician because the examining committee members may want to speak to the doctor, find out more about the diagnosis or the prognosis. We do have to list what rights we're considering removing from the individual. And if we do have any next of kin, they have to be served with a notice of these proceedings. The court-appointed attorney, they're only representing the interests of the child. So they are going to be separate from the petitioner, they're going to be separate from the guardian, any other players in this system. They can only be on one side of the fence. And that's obviously as it should be. But sometimes you'll see in the guardian advocacy proceedings, it's a little bit different. Sometimes the parents get confused because they're unrepresented, thinking that their child's attorney then becomes theirs. So I just want to make the distinction. It's the child's attorney. Yes?
Could you make a comment on how often in your experience does the attorney go against the petition the child?
Rarely, but that doesn't mean they don't. And I say that because there are court-appointed attorneys, and I've done training with them, and it's honestly a tough role. Because if they're representing the best interest of their client, I think we could all agree that none of us would want our rights removed. If someone were to ask us that question and we were able to understand it, no one would say, yeah, take away my rights. So if they were to argue their client's position, but it's a young adult that's nonverbal. So how do they then represent the child's interests when the child can't tell them? And so there is a certain protective mentality, I think, that some of the court-appointed attorneys will take. And then there are some that will adamantly oppose it and certainly make the petitioner prove their case. And there are plenty that are somewhere in between.
One more. How many times do next of kin come into court and fight you?
It depends on the family dynamics to begin with, because what I will tell you is in my experience, and keep in mind we're talking about guardianships from somebody that's 18 to 104, most family members are only fighting if there's money involved. I mean, it's the reality and kind of the cynic world, unfortunately, that I live in. But in most of these cases, you're talking about children still with Social Security benefits, and even though they're minimal, in my opinion, $771 a month to live off of is not excessive, there are still families that would fight over that. So if it's a position of control and they're fighting just for the sake of fighting, it doesn't matter, they're still going to do it. So, I do see either competing petitions or petitions that are being opposed, not regularly, but often enough. Yeah.
In the circumstance where I know that the department is tasked with identifying a petitioner or a person to serve as a guardian or guardian advocate, but do they have the legal responsibility to prosecute the petition to establish the guardianship?
Well, keep in mind two different issues in that question. The petitioner does not necessarily have to be the one asking to be appointed. You could certainly petition for someone else's appointment. So the department is certainly empowered to start the proceedings. Correct. Whether or not they have the fill in the blank who the person is going to be is a different issue. But certainly, again, the petitioner does not have to be the one asking for their own appointment. And in some cases, the judges can consider that self-serving, but normally when it's a family member, there's not normally a conflict in doing so.
I'm an attorney for the child, and I specifically do special needs. So I have a situation where they don't want a guardian advocate, but they're in all kinds of situations, dangerous, pages and pages, paper accident. And so I'm his attorney saying, they don't want one, but everybody knows he's in care most of his life. He needs one.
And that gets back to the petitioner then proving the burden, not you.
But I can't be that person saying he needs a guardian advocate because it's a conflict against him. But everybody knows he needs one.
Exactly. And that's obviously the tough dynamic that a lot of court-appointed attorneys end up in the how hard do I fight if I really kind of recognize this young adult still needs assistance. So ultimately, Florida bar rules still apply. We're not throwing those out the window. So just as a side note there. But the examining committee, this is a little bit of the piece that's going to be different from guardian advocacy. The court appoints 3 individuals, and under the statute, it's normally a medical doctor, could also be a neurologist. Then we also have what I call the ologist level, so it might be a psychologist, a gerontologist, sociologist. It could be another physician as well. And then we have someone normally at a nurse, a social worker, that level, someone with the experience to obviously give the testimony, the evidence to the court. And they're going to go out, they're going to meet with the alleged incapacitated person, and they're going to fill out a report to the court that then gets filed. And for the most part, that is then accepted as evidence. You could certainly object to it. Could be, on the grounds of hearsay, and then we drag in the examining committee to give testimony, but that's rare. Again, if we have somebody maybe fighting tooth and nail, that might come into play, but normally the court accepts their reports as the evidence and their findings then of what rights in particular they think the person can or can't do. And we'll talk about those rights specifically in a minute. But ultimately, you also might have other witnesses, other testimony that you're going to be providing to the court. So these are just 3 individuals that are appointed by the court. They're qualified by the court to then give the court this expert opinion, if you want to look at it that way, as to the incapacity. And there are some specifics in their report. So obviously, if someone else was answering the questions, the day and time that they went out, because that might also impact someone's capacity. We all have good days and bad days, so even just to know that they went out on a different day. So there's certain nuances that are required in their report for protective purposes as well.
What do they do with a non-verbal client?
Most of the doctors, again, are pretty good about that. So, if they try to meet with them, they can't give them a lot of a lot of feedback, a lot of information. This gets into when we talk about other supports. Well, what about a communication device? Was that child maybe never provided with that opportunity? So, do we need to look at even an interpreter? So the petition, things like that, do have to address like the child's primary language, so that the examiners have an idea, at least before they get out there, what to expect, and then they can frame their questioning around that. But that's where if they have any sort of assistive devices, we want to make sure that they're available during those examinations as well. Same thing with our elderly. If somebody doesn't have their hearing aids on that day and somebody's asking them questions, they may not respond appropriately. So we'd want to have that same sensitivity with the children's disabilities as well.
Where does the court typically get the names for the examining committee?
So the question is, where did the court get the names for the examining committee members? They're normally, there's an application process so that they actually apply to the court to become an examining committee member. It used to be back in the day where you could kind of pick your examining committee members if you wanted to stack the deck in your direction. Same thing with the court-appointed attorney. We've done away with that. So in most circuits, there is a list, and they're assigned by the clerk, so that we don't have that. There are some circuits, though, that are short on examining committee members, and they're kind of desperate to have them. So we certainly might have an area where there's a shortage as well.
Is there an instance where counsel can have particular parties excluded from the examining committee, or is there just attachments or anything at all, or do we have, does counsel have no say in so far as the selection of that committee member?
So the question is, what if counsel might have a concern about an examining committee member that might have a pre-existing relationship with the AIP, the alleged incapacitated person? That would be something that certainly you could ask the judge to reassign or to issue an order with different examining committee members. I think it certainly would depend on the nature of the relationship and which side you're on. That could either work, again, for or against you. So we've got the reports that have to be served on the petitioner and certainly the attorney for the AIP within a certain time frame. And the examining committee has about 2 weeks. They've got 15 days to get out and do their evaluations. And then that hearing is supposed to be set within about 10 days thereafter. So if you're doing the math, we're talking about a 30-day process just in this window to get to the courthouse. Then ultimately, we've got the hearing that's going to take place, and the standard of evidence is clear and convincing. So we want to make sure that the court has enough evidence to find that there is an incapacity. And ultimately, again, we've got those reports, we might have other witnesses, but then the issue becomes, if now we have determined there's an incapacity, who's going to be the guardian? And the statute makes it a little more interesting for us. Florida resident, 18 or older, essentially a non-felon. And there's current language in the statute that says otherwise not unsuitable. How do you define unsuitable? Because the statute doesn't, so that's why I asked. I've always wondered. What's unsuitable to you may or may not be unsuitable to me. So it kind of gives the court a certain amount of discretion to either qualify or disqualify someone. I do want you to know 744 is currently undergoing a major rewrite. We're actually looking at moving it to a whole new chapter. So if it passes, which it may be next legislative session, it would be chapter 745. So all of this would then become whole new references for you. But they're talking about getting rid of unsuitable in that rewrite.
I know I had a
I'm with you on that.
My understanding is that Florida is strict.
It doesn't matter. Yeah, those are what I joke and kind of call the kind of good felonies. You know, it wasn't anything that bad, but back then it was still, you know, rose to the level of a felony. Doesn't matter. One strike, you're out. I had a client recently that actually had gotten clemency from the governor. Judge wouldn't appoint him.
Because I know other states, I researched it.
Other states are more discretionary. Florida, and I do a lot nationally, Florida is one of the strictest, and I think it's also because we've had a lot of, unfortunately, bad guardians that have hit newspapers and things like that, and I'd rather err on the side of caution than certainly opening it up for exploitation or abuse. And certainly for children that have already gone through the system, we want to make sure that they're a qualified guardian. But there is, unfortunately, no wiggle room currently with felonies, and it's a felony conviction. So if they are a non-Florida resident, we can look at that family line, and we can even get into marital relationships, so the spouse of someone related by blood or marriage. So I would say it's kind of broad. You could dig kind of far and wide, you know, third cousin twice removed. And it really gets back to if nobody's going to challenge them and they otherwise qualify based on the application and background check and credit report, that sort of a thing, nobody else is asking to be appointed, they might very well win. Okay? There we go. So the disqualifications, the felony's clear. Obviously, if you have your own incapacity or illness, you can't be appointed. Those are some of the obvious ones. The one that Jess highlighted for us, the judicially determined to have committed abuse, abandonment, or neglect. We're obviously not going to, you know, throw the child back into a similar situation. So that's common sense. Found guilty, there's a whole list of offenses under 435. So chapter 435, I will tell you a lot of them deal with sexual violence, domestic violence, kidnapping, you know, those sorts of things that normally are not going to come up as often, or chances are there's already a felony conviction there for something in one of those categories. But 435 is going to give you a whole list of other disqualifying criteria. All right.
And the reason that I wanted to
I'm
jump...
sorry, I heard something about a felony?
I was saying convicted of regardless of the crime.
Regardless. That's why I say kind of a nice felony, you know, still out.
So the reason why I wanted to bring up this slide at this point and why it's so very important is that when parents consent to dependency, there's a finding of abuse, neglect, or abandonment against them, which means they are ruled out. Look at our hypothetical. Ashley was 5 when she was removed from her mom's care. Let's flush out those facts a little bit. Say Ashley was 17 herself. Right? Ashley's mom was 17 herself when she had Ashley. So then now 12 years have gone by. She's gone to college. She has been working with her great aunt to care for Ashley. She's a specialist. She's an ABA licensed behavior therapist. She is ready to resume care of Ashley and be her guardian. Nope. She is done. She is not able to do that because of that judicial finding. So the reasons why I said watch out for consents for dependency, if there is a parent that is coming into the system because they are unable to manage their child's behavior or special needs, this is a great time for prevention or in-home services. If the family is able to work with service providers or APD and the parents agree to place the child in an APD home, maybe where there are services in place, the department doesn't need to take custody. You could do a withhold of adjudication so those findings are never made against the parents and the parents aren't ruled out in perpetuity. Okay, here's my crazy legal suggestion, is potentially at the end of the case, ask for a vacation of the finding of abuse, neglect, and abandonment. Not really allowed for under the statute. Not really prohibited. Well, actually, not prohibited at all. It's silent on that in the statute, right? But who's going to appeal that, right? So I think we've got to think of creative advocacies. And then I think on the legislative front, I'm thinking this is a great part of 744 being rewritten that says that a parent that has been found guilty of abuse, abandonment, and neglect may not serve as guardian unless the juvenile court has found that those circumstances have been remedied to such an extent that blah, 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 blah. But that does not exist right now. But that's where I think the legislative change needs to come. It's clean, it's simple, it's clear. You can take the language for free. The other thing too is case plan completion and reunification doesn't cure it. That finding is still there, it exists. Those folks are out of the picture. The other thing is that Chapter 39, you heard Michelle just say that here are all the lineal relations that should serve as guardian. Chapter 39 says they cannot serve as guardian. Again, I love the statute. They cannot serve as guardian unless there's been a finding that those folks serving as guardian is in the child's best interest. So we want to make sure that the juvenile court makes those findings before it closes its case, terminates its jurisdiction, because you don't want to have a perfect adoptive parent, a grandma, a brother, a sister, a cousin being the perfect guardian, and you run to probate court and then suddenly, whoops, you didn't get that finding in Chapter 39 before the dependency case was closed. So that piece is really important as well. Lots of hands just went up. Sorry, did I just step on people's toes? I'll go this way.
I don't know what you mean about the court finding best for one.
Thank you. Let me be clear. The question was, what did I mean? Because clearly I didn't say that correctly. So Chapter 39 says that relatives, including adoptive relatives, may not serve as guardians unless the court finds that that's in the child's best interest. So that contradicts what Chapter 744 says, where it says we have a preference for all these relatives. So what I'm suggesting as an advocacy strategy is to make sure that the dependency juvenile court makes the finding that relatives can serve as guardians if it is, consistent with the facts and it is in the child's best interest. So that's just a conflict of the law. Sorry.
Does that include a parent or an adoptive parent?
So it actually says adoptive parent in Chapter 39, which is just, don't you wish that you were in that room when they were writing the law? Because someone had a story that people were like, ooh, we got to include adoptive parent, but I don't know what the background for that is, but that's what it does say. It's easily overcome, right? You've got adoptive parents who are doing everything right for the child. You just file a motion with your dependency course saying this child may need a guardian. These people are stepping forward to adopt. It would be in the best interest that these people be allowed to serve as guardian post 18. But that's probably a good idea to do it before the adoption goes through, because you need that finding from the dependency court.
A follow-up, and I might be getting ahead of myself, so stop me. Is the same prohibition apply to guardian advocacy?
Yes. Sorry, I had to think about that for a second. The question was, does that same prohibition apply to guardian advocacy? Yes, this is language that comes out of Chapter 39. So it falls under the Regis Little Act. So it applies to both all types of guardians and guardian advocacy.
Is there a necessity that the dependency court, the both circuit courts, and the probate court make that finding?
So that's a good question. Could the probate court make that Chapter 39 finding? I think it could. If you didn't have it, I think you could argue that finding could be made there. I think it's cleaner to make it in the dependency case. I do worry about a probate court saying, well, I don't have the juvenile court records, and so how can I make that finding? But I think if it wasn't made, I certainly would not let it stop, just like the young person that has a potential guardian out of state, and that other state might allow that person who was a good felon 20 years ago to be the guardian. I might look to see, does the young person want to live in Hawaii or North Carolina or wherever that person is? I'm just thinking outside the box. Okay.
All right, but you're going to write down the language that you want to change in 744 so that I can forward that to the committee, because that was a good suggestion. All right, in the interest of time, I'm going to go a little bit quicker with this. So there's going to be an order, obviously, appointing the guardian, spelling out exactly what authority they have, as well as an order determining the incapacity. The rights that are always retained, you got to know the ones we keep before we talk about the ones that we take away. The ones that the individual is going to keep are intuitive, things like the right to be as independent as possible, the right to privacy, the right to have counsel, the right to be restored to capacity. So those sorts of things that, for one another, we would want to maintain. But the rights we're talking about removing, the right to marry, the right to vote, the right to personally apply for government benefits, to drive, to travel, to work. Firearms is ultimately, it's going to be in the rewrite. Right now, it's something the judges are writing in because of changes in 790, where now if there is a mental health disability, so the incapacity is going to now kind of pick up and address firearms. The right to contract, actually that should kind of be over in the other column, just on the slide, but the right to sue and defend lawsuits. The right to apply for government benefits, the only distinction between those two is the word personally. And we'll talk about these two columns in a second. To manage property, determine residence, medical or mental health treatment, and social decisions. So literally what we're watching on TV, who we're hanging out with, what we're doing in our spare time. So the first set of rights, if you stop at firearms, are what we consider personal rights. And those are rights that may be removed, but they are never, ever delegated to a guardian. You can't go vote on behalf of someone else. You can't get a driver's license on behalf of someone else. I'm still trying to figure out how someone else goes to work for me, and I collect the check. But those are the sorts of things that you have to personally do these things. So those we consider the personal rights. Contracting, defending lawsuits, benefits, property, medical, mental health, and social, and residence. Those are delegable rights. Those are rights that do or could go to a guardian. So I used to tell people, as a professional guardian, I could control every aspect of your life with those 7 statements. So that's why I take this process very seriously. When we are talking about removing someone's rights to do things independently, individually, and again, those personal rights. Pay attention to these just for a second, because they are going to be a little bit different when we talk about guardian advocacy. Okay, so trying to just get there quick. The credit and criminal investigation, again, we need to make sure that that guardian is qualified, so they are going to do a background check, credit screening. They don't have to have a particular score in the statute, but we want to see, obviously, if there's a risk for exploitation, just acting as a fiduciary, we want to make sure that they're qualified. The duties of a guardian, you can see the laundry list there, but think about if someone were making decisions on behalf of you, everything in your life. You know, got to get groceries, got to pay the bills, where you're going to live, your doctor's appointments. So ultimately, everything that goes along with any of those decisions. The letters of guardianship, that again is just going to be the proof of the authority to the rest of the world. It's normally a single-page document. Sometimes you'll see 2, but really it's going to spell out everything that'll tell you what you need to know about the guardianship, whether it's limited or plenary. And that deals with whether all of those 13 rights were removed or only some. If it's a complete guardianship and you see the word plenary, then you know all of the rights were removed. If it says limited, you got to figure out which of those rights, whether they were personal rights or delegable rights, which rights did the person keep and which rights went to the guardian. So just looking at the title of the letters of guardianship will sometimes tell you if it's everything or it's just a little bit. And then they'll be enumerated in the document. The authority starts on the day the judge signs the letters. I get a lot of guardians that they say, well, I went to a hearing 2 weeks ago. I said, well, it doesn't matter. Until you're appointed by the court and you have those letters of guardianship, you don't have the authority. Then the statute also tells us what we can and can't do with and without a court order. So there are certain decisions that the guardian may have to come back to court for, and there are certain things where they may not. A lot of it would involve property, so selling property, purchasing property, things like that. If you're going to create an obligation, I know it may not come up in a lot of guardianships of a young adult, but ultimately you'd go back to court. A lot of the medical decision making, not so much. There are some cases, come on, there we go. Some cases where we do have to go back to court on the medical side. So the involuntary placement, that we're talking more specifically under a Baker Act or a Marchman Act. Experimental procedures, it does come up nowadays in drug trials. So there might be a new medication that maybe the doctor wants to try. If it's still under a drug trial, technically we need the probate court to authorize that. We can't dissolve marriages and terminate parental rights. You know there are different proceedings for that, so probate court, the guardian is not empowered to do that. And sterilization or abortion. Those reporting requirements, again, we've got initial reports that the guardian's going to have to file, and then ongoing annual reports for the life of this guardianship. How does it end? I told you in the beginning, normally unless that child can be restored to capacity, the guardianship ends at their passing. Sometimes if we move out of state, it might be a termination of the guardianship here in Florida, but we still have a guardianship somewhere else. They might call it a conservatorship, they might use different terminology, but we may still have someone making decisions on behalf of that individual that is incapacitated. The removal as a guardian, obviously if we have bad guardians, we have a process to remove them. So then how is guardian advocacy a little bit different? Well, it was intended to kind of sort of be guardianship light. It is under a different chapter. We have in the rewrite talked a little bit about maybe moving it into 744, but it's not there yet. Jess gave you the criteria under 393 of the developmental disabilities that we're talking about specifically. If it is something outside of this, guardian advocacy is not going to be an option. So if you have a young adult and the primary diagnosis is mental health, not going to be a guardian advocacy. It must be a developmental disability. Yeah. I'm sorry?
Congenital heart defect.
But does that make them incapacitated? It would then fall under a guardianship. That's more, it was a congenital heart defect was his question. If that's the nature of the incapacity, more medical, so obviously that would be something that is not going to be covered by the developmental disability. Yeah.
Earlier you talked about moving from Florida to another state. How do you transfer the guardianship, or do you have to start all over again in the new state?
Unfortunately, today, Florida does not participate in a uniform jurisdictional act that allows for reciprocity. However, coming out of Florida to a different state, because Florida, generally speaking, has a little bit higher criteria for some of the ways that we handle this, the other state might be more accepting of the documents that we have, but you're still going to have to open a new file, again, in that new state to transfer it there and close it here. Where guardian advocacy is going to get tricky is we don't necessarily have something reciprocal in most other states, not any other states that I have found yet, specific to the developmental disability population. So and this primary difference that we'll talk about is because you don't have an order determining them to be incapacitated. We'll talk about that in a second.
So just to clarify, I think a lot of states, you're going to need a new petition and a new court order.
Starting the process all over in the new state. But you may not have to find them to be incapacitated. Again, if there's an order finding them to be incapacitated in Florida, normally the other state will just be looking to appoint the guardian or the conservator in that state. They don't have to go through the incapacity proceedings. The statute doesn't give us a specific. So I have seen that's where sometimes the judges and general magistrates, depends on what they're looking for. And a lot of times they are using an IEP for the evidence. Anna Mary?
If we have a child that's moving out of state, and oftentimes those changes occur very quickly, is there any kind of leeway that's given to either expedite the process in the new state, or since it hasn't been approved in the new state, to ensure that the documents from Florida still apply? Should anything happen between, any sort of bridge coverage or anything like that?
Unfortunately, it gets back to if there's a slim chance they could be maybe opening one out of state before you start in Florida, look in that new state. It kind of gets back to the statement about if you can do it in Hawaii, do it in Hawaii. But if you start it here, then it's going to be a transfer issue, and there is going to be a certain gap just in getting the file open up there, or over there, or wherever it may be. Okay, so with that categorization there, what's a little bit different? So again, has to be a developmental disability when we're talking guardian advocacy. The petitioner is not required to have an attorney. The guardian, FYI, has to have an attorney throughout the life of the case. Under guardian advocacy, if only personal rights are being addressed, none of the financial rights, so no contracting, no lawsuits, we can get away with the petitioner being unrepresented. A lot of families like that because it's cheaper. Okay? There's no examining committee. There's no order then determining them to be incapacitated. We don't talk about those personal rights in a guardian advocacy at all. They are not addressed. So the right to marry, the right to personally apply for benefits, to travel, to work, all of those that we were talking about as personal rights do not get considered in a guardian advocacy. There is then no finding of the court that this person is legally incapacitated. We basically accept that developmental diagnosis as the basis of the incapacity. I got some issues with that. You say someone's autistic, does that define what they can or can't do? So, but we are using that as the criteria in a guardian advocacy. So what's a little bit different, we don't send the examining committee out to make those findings. We accept their IEP, we accept a letter from their psychiatrist, we accept whatever documentation we have, that goes to the court, and then it becomes the issue of who are we going to appoint as a guardian advocate. They have to qualify just like they did under 744, the disqualifications are identical, and the difference is, again, we don't have an order determining the incapacity, we literally walk out with the order appointing that guardian advocate, and then all the rules under 744 are similar as far as the plans and the reports that are required. So the distinction is, has to have that developmental disability. We do not take away, we do not address, we don't even talk about those personal rights. And if it is just medical, mental health, social, and residential decisions, and we normally include educational decisions in that, the petitioner does not have to be represented by an attorney in most circuits. Okay, so that's why it's kind of a guardianship light. Estate planning documents, though. I like, this is when I get on my soapbox, I like that everybody over the age of 18 has a power of attorney and healthcare documents. In case something were to happen to you, you have an agent to act on your behalf. That's just being prudent. Most of us don't plan. So a lot of times we forget that a young adult over the age of 18 might still have capacity to sign documents if it can be they can understand it in their terms, and they could name an agent under a power of attorney, under a healthcare surrogate designation, and we stay out of the court system. They have to have the basic ability to contract, to understand what it is they're signing, but this is where we have alternatives. So, representative payee for Social Security. We don't have to go to the guardianship court to have someone named as the payee for Social Security. So that's why a lot of times that right to manage public benefits doesn't really even have to be addressed by the court, because you can do it through Social Security. The advocacy services, some of that you already know about. Supported decision making. You use supported decision making all the time. Well, maybe we should have when we were making those bad decisions. Anybody ever made a big decision and you ask for some input from people you trust? That's all supported decision making is, but we give it a fancy title and we use it more specifically in the developmentally disabled population. But it's putting together that support team. It's developing that plan to maybe give some boundaries to say, I'm going to make this decision independently, but if it involves these other pieces, then these are the people I'm going to ask to come in and help. Yeah.
On Rev Payee, how do you feel about payee group homes in the rest of
Me personally, generally don't like it. And the reason I say I generally don't like it is because what if we ever need to move the placement? Normally, if you're a guardian, the court's delegating that right to you. You can't delegate it to the group home. So if the court appoints a guardian with the right to manage the benefits, they should be the payee under the authority the court's giving them and not delegating that to the group home anyway. But it gets back to the decision maker ultimately should be the one in control of where the rent's going. Okay, so can we avoid the court system? And I think this is where Jess started some of it. We're very quick to jump to a guardian or a guardianship being the solution. It's not always. Maybe it's a guardian advocacy because there's a developmental disability. But what if we could keep that child out of the court system for the rest of their life? And ultimately, they could understand basic estate planning documents to name someone to act. And what's the beauty of the estate planning documents? We don't have the felony issue. We don't have the out-of-state issue. So some of those disqualifiers go away, as long as they are a person that individual would trust with those types of decisions. You don't obviously hand over those decisions to just anybody.
Two quick questions. So first, the examining committee's decision, how long is that expired after a certain period? Does it have to be conducted again after? I know every year you're filing, but in the event that we're looking to perhaps restore some of these rights, what is the process? Just very
Okay, right, so real quick, because I know we're down to about 5-10 minutes. So restoration can happen at any time. The examining committee reports don't expire because it's one of those things that the court's ordering the incapacity or determining that the person is incapacitated. So in order to basically overcome that court order, you have to start the process to say, well, we think they could have some rights back. And a restoration can happen at any time. It's not time sensitive. You could literally have someone found to be incapacitated and they could file a suggestion of capacity the next day, same day for that matter, and then the court would make a finding on that suggestion. When it comes to a guardian advocacy, we can restore rights as well. The difference is we now still, just like we use the medical evidence in taking away those rights, we use the medical evidence to give it back. So if we find a doctor that writes and says there isn't that incapacity to do these things anymore, then the court would use that as the evidence. So it's a process that could be reversed. And because now we're down to 5. Just real quick, the Turning 18 website was something to help, originally my intention was that it was going to help families navigate between these 3 primary decisions. Is a guardianship appropriate, a guardian advocacy appropriate, or estate planning? And they could kind of see the child in this scenario. And the way it was designed, if the end result is guardian advocacy, it'll help family members fill out the forms. And literally they could go take them to the courthouse without needing representation. What we've seen evolve, kind of unexpectedly, is that legal aid programs and attorneys started using the website. And so now we're looking at, do we need kind of a 2.0 version that might address some of the legal community's needs to be able to modify and tweak some of these pleadings a little bit differently. So that's ultimately, the resource that we provided, so that somebody's sitting at home or sitting in their office and they're sitting there struggling with which direction do I go for this child, you now have a website that's literally going to kind of walk you through what those end results might be and remind you of all this information we just kind of threw at you real quickly.
Earlier, you had said we come back to.
Okay.
We're doing it. We're trying to get there.
Okay. So let's talk about the strategies that we can use in the foster care system or the child welfare system. The first thing is we've talked about is prevention services. Don't remove, withhold adjudication if possible. Allow families to work with service providers rather than bringing them in the child welfare system for services only. I'd like folks, and these materials are in your packet, the second bullet says ongoing family finding to find non-placement relative resources. I'd like people to add the word ongoing family finding and engagement, because we've all been in those meetings where we do family finding and grandma or Aunt Susie or Uncle John or older brother Tom say, I am not a placement resource, and what do? And we move to someone else, right? What we need to do is go back to John and say, all right, we know that you love Ashley, your little sister. What can you do to help? And he might say, I'm an accountant in Tennessee. Ding, 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 we've got a rep payee. We may have a guardian who might be able to manage the financial literacy. It doesn't mean that he has to take custody, but he's a resource. So we need to do ongoing family finding, and it needs to happen. Let me give you a quick example. I'm on a case, we have dismissed Mrs. Smith because she wasn't a placement resource 5 years ago. I cold call her. Hi, Mrs. Smith, this is Jessica Ray. I represent Ashley. We need your help. What is she going to do? She's probably going to say, well, I don't know who you are. No one's talked to me for 10 years. Ashley's been in the system for so long. What happens if I say, hey, Mrs. Smith, it's Jess. It was really good to see you at Ashley's IEP last week. How are things going? Remember you said that you'd be able to take Ashley to the doctor? Are you willing to sign her circle support agreement? She's probably more likely to talk to me if we've already engaged her throughout the case, right? So we need to be doing that. And look at the difference of the two lists. For guardian and guardian advocate, parents are usually ideal if they haven't been disqualified, and most of our parents have been, right? Unless there's a withhold. So they're gone. Siblings, if they're over 21, I don't know why I said that, it should be over 18, so cross that out, it should be 18, sorry about that. Relatives, I put the stars because they have to be lineal, but not really, because if you look at the statute, they don't really have to be lineal, they can be married to someone who's in that line. Family, friends, or professional guardians, and we know that we don't have enough professional guardians in Florida, so don't count on this at all. Look at the list for the circle of support. It's anyone and the orthodontist, right? So if we can do this, we have a much bigger target pool of support that we can pull together for the young person. But the way that we have to do it is we have to go back to our basic child welfare advocacy. I heard Alan this morning talk about the new law that allows us to file for advocacy in the county where the child lives because so many kids are placed out of county and everyone's like, woohoo! I'm sitting in the back of the room saying, boo! Why? Because that's bad, because it means that we didn't place the child least restrictively at the get-go. The child is in another county. Why are we accepting the fact that our kids are all placed out of county? And isn't it weird that everyone's kids are placed out of county? So like the Hillsborough kids are in Pinellas, the Pinellas kids are in Pasco, the Pasco kids are in Hernando. Can't we just move the Hillsborough kids back to Hillsborough, the Pasco kids back to Pasco? Like, why do we accept that as advocates? So we need to start to push for kids to be least restrictively placed so they're in contact with their families. Why? Because if we encourage visitation, then we're going to have Mrs. Smith, who's visiting Johnny throughout the years, and can be an advocate for Johnny later on. If we have relatives that are engaged with young people, they are more likely to step up at 18 rather than when we cold call them a week before the child turns 18 because we're panicking. So what I think good circles of supports look like is high quality case advocacy throughout the life of the case. In Ashley's case, she comes in back into the system later on, but we need to be thinking about, can we re-engage mom? Can we find out who the family friends are? Who's important to Ashley? She tells us that she's running. Who's she running to? Why is she running? Does she necessarily need an advocate? Because if we think that a guardian is going to stop her from running from her placement, we're wrong. Guardians aren't jailers. They're not something that we can hand over a troubled kid to. So we need to think a little bit more broadly about making sure that we demand that the advocacy that kids need is done throughout the case. Because it's not just something that, well, if there's a guardian, we can move this kid off our caseload and someone else's problem, because that's not how that works.
Well, and Jess, I want to add to Ashley's scenario just a little bit. I know you're picking on professional guardians. I'll defend them just a tad bit.
Oh, no.
No. I know you're not picking them, but I don't want to rule them out as an option because, and this gets back to Ashley's situation a little bit, as a professional guardian, I don't want custody of the child. I don't want to be the day-to-day caregiver. But as the guardian, I could decide that mom, who again is disqualified as a guardian, could be the appropriate caregiver. So it kind of gets you, I don't want to say the best of both worlds, but ultimately if mom is engaged and involved, but she might be disqualified, maybe there is a professional guardian in that instance that would serve to oversee and supervise and make the medical decisions, and it's ultimately the guardian making the decision that mom is the appropriate placement. So if you can separate out those two issues, you might also open up your pool of individuals.
And then I just have to say in Ashley's defense, I see nothing in the hypothetical that suggests that she needs a guardian. There may be some facts, but they certainly aren't presented in the hypothetical at all. She looks like a kid that's running away from a group home after her caregiver of 12 years died. She's sad. Kind of makes sense to me, right? And so that just shows that we need to have more facts about kids before we start to make these lifelong decisions for them that can last in perpetuity until that young person dies. So Regis Little does not equal guardian. Everyone got that? Yay. Thank you very much.